Hi guys, my name's Stu. I'm the co-founder and CEO of musiCircuit, a web app that helps UK musicians locate and connect with other like-minded musicians to collaborate, form bands and fill vacancies within bands. We're really excited to be launching later in the month, so do keep an eye out for us. In the meantime, I'd like to give you an educational talk on how UK copyright law would apply to the common scenario of a band creating an original music track or video and uploading it onto one of the popular platforms. By the end of this video, you'll understand how to identify each copyright work within your music track or video, how to identify who owns each copyright work, and how to avoid infringing someone else's copyright. The reason why this is important is copyright allegations can be very serious. In the worst case scenario, they can lead to civil proceedings against you. As is more commonly experienced, it can lead to the relevant platform taking action against your creative content at the request of the rights holder. So for instance, YouTube muting your audio, blocking your video in its entirety, or enabling the rights holder to monetize your content. Neither of those are good outcomes for you, and what I'm going to do is help you avoid them and realise your musical ambitions. Now, before we can get to the good stuff, we're going to have to go through some thrilling UK copyright law. In all seriousness, I'll try and make this as quick and painless as possible for you. But for a work to attract copyright in the UK, it's got to satisfy three requirements. The first, it's got to fall within one of the defined categories of work protected by copyright. And I've listed those below. You need not know each of them. We'll go through the ones that are most likely to apply to your music track or video shortly. The second requirement is that the work's got to satisfy various territorial factors. Now, you'll be absolutely fine if the author's British or lives in the UK, or the work's first published in the UK. We don't need to go any more complex than that. The last requirement is that if it's what's called an original literary, dramatic or musical work, it's been recorded. It's commonly known as fixation. Really, it just means has it been put down in writing or otherwise. And that's it. So if your work satisfies those three requirements, you'll have copyright in that work automatically. No need for any registration or application like in some other territories. It's really good. And that protection will last for, in most cases, the life of the author plus 70 years, so quite a considerable amount of time. There are certain variations for some works, but we need not go through that here. Now you have a good grasp of basic UK copyright law, let's apply it to the practical scenario of you or your band creating an original music track or video. The first thing to do is to split your music track or video into the works that might qualify for copyright protection. So a standard music track will have three things: lyrics, a musical composition, and an audio recording of the two. If it's packaged up as a music video, there'll also be a film. Let's see which category of copyright works each of these elements of creative content fit into. So starting with the lyrics. Assuming that they're original, and what I mean by that is a result of the author's own intellectual creation and not copied, they'll be protected as a literary work. Now, a literary work is basically anything written, spoken or sung. Moving on to the musical composition. Again, assuming it's original, this will be protected as a musical work. Now, it's important to note that what we mean by a musical work is really the notes or other elements of the composition possibly, but it shouldn't be confused with the recording of the overall song or the lyrics. Let's move on to the audio recording. This will be protected as a sound recording. And the film, you guessed it, a film. Great, so we split down our music track into three separate copyright works and our music video into four separate copyright works. Now let's figure out who owns them. It can be a relatively complex subject, but what I'm going to do is give you a simple roadmap to follow to work it out. So what you're going to do is take each of the identified copyright works in your track or video and go through the following simple steps in order to identify the owner or owners of those works. The first thing to do is to identify the author of each copyright work. Now, this may be more than one person, but before I go into what constitutes joint authorship, it's first important to understand what we mean by author. Sounds simple, and it is. It's the person who creates the work. So that's really obvious for your literary and musical work. it's the person who wrote the lyrics or who composed the music. However, the author for a sound recording and for a film is specifically set out. For your sound recording, the author will be the producer, in other words, the person who makes the necessary arrangements for making the sound recording. For your film, the author will be the producer and principal director. Now that could be the same person, or it could be more people, and that leads me nicely on to the second question you should ask for each of the works. Have they been jointly authored? Now, what do we mean by jointly authored? As is often the case with bands composing music and lyrics and content, it's done through a process of collaboration. But for the end product to be a work of joint authorship, two elements must be present. The first, the work has to have been created through a process of collaboration. The second, the contributions of the different authors can't be distinct from each other. If you can separate out the contributions, they're likely to be separate authors of separate copyright works. Now, for a joint author to claim rights in a work, they must show that they've made a significant and original contribution to the creation of the work pursuant to a common design. Now, this is the source of many a dispute between members of bands when their songs gain popularity and people start to stand to gain financially. If you want to avoid this issue and lend clarity to ownership of your music track or video, you should set this out in a joint ownership contract between all members of your band. Once you've identified the author or joint authors of each of the works, you should make sure that each author is a qualifying author. Now, we touched upon this before. If they're British or live in the UK, they're likely to be qualifying authors. Now that you've identified the qualifying authors and joint authors of each of the works, you can now identify the first owners. Now, as a general rule, the first owner or owners will be the author or joint authors of the particular work. Now, that's unless they're an employee who created or contributed to the relevant work in the course of their employment, in which case their employer will be the first owner. So there's a practical tip here. If you want to avoid a situation where a copyright work in your music track or video is owned by your employer or an employer of a member of your band, you should each ensure that you write, compose, record and film the track or video outside of work hours, not on employer premises, and not on any hardware owned by employers. And I just want to touch upon commissioned works here, because there's a common misconception that if you pay, for example, a session musician to lay down a guitar riff on one of your tracks, that you will own that guitar riff. Now, we know that's not the case. The session musician will be the author and will therefore be the first owner unless they're doing it in the course of employment, in which case the session musician's employer will own it. So if you want to own copyright in works created by third parties and you've paid for those works, you should make sure that the contract contains a transfer of all copyright in their contribution to you. So you've identified who the first owners are for each of the works. Now, you just need to ensure that none of the owners have transferred or part transferred or exclusively licensed copyright in their work to a third party. Copyright owners are free to commercially deal with their work as they see fit. And that's unless they're a joint owner, in which case they need the permission of all of the joint owners to do anything with the work. The practical tip here is, if your band or a member of your band has a record deal, a manager with publishing rights, or a music publishing deal, this could be relevant to you. You should identify whether there are any contracts in which you or a member of your band has assigned or exclusively licensed copyright in their creative content.
So now you understand who owns each of the copyright works in your music track or video. The last thing you need to do is learn a little bit about copyright infringement and how to avoid it.
There are 3 questions you should ask yourself before doing anything with your track or video to avoid infringing copyright in someone else's work. The first, do you own copyright in all of the works in your track or video? If so, great, you can do what you want with it. Now that will mainly apply to the singer-songwriter type who does absolutely everything at his or her home studio. The one word of warning I would give to this person is make sure nothing in your track or video, however small, has been created and is owned by a third party. Now I've listed some examples there for which you should make sure you have the right license to use. Secondly,
If you don't own copyright in all of the works in your track or video, do you have permission from each and every owner and joint owner to use their work in the manner you desire? There are two scenarios I want to focus on here. The first is where a third party outside your band owns copyright work in your track or video. The bottom line is, don't do anything with their work until you have their permission to use it in writing. This is usually in the form of a license. The second scenario is where you or a member of your band owns all works in the track or video. You may be satisfied with nothing formal in these circumstances. Your band will likely know and agree to you using their work. This is what we call an implied license. But implied licenses are far from certain, and bands frequently fall out. If you want to avoid a situation where a disgruntled member, perhaps, can retract permission for you to use his or her work in the track or video, you should get their permission to use it in writing for all time at the outset. If you don't stipulate that the permission is forever, they can always revoke it. The third, and probably the most important question is, are you sure that each of the copyright works in your track or video have not been copied, that's whether wholly or substantially, or adapted from another person's original work without their permission, and that's by you or a member of your band? A copyright owner has various exclusive rights in their work, and I've listed them there. If you yourself do any of these acts without their permission, you'll be committing an act of primary infringement. Now, I'm not going to go into all acts of primary infringement here, but rather focus on the most common one, copying. The first rule is, you'll know if you've carbon copied, just don't do it. I've put a note here to be careful when covering songs. When covering songs, you'll necessarily copy the original work, and technically you'll need to get the appropriate licenses. Now, I'm not going to go into the legal aspects of covering songs here, but I'd happily cover that in another video. As musicians, we all have our influences and heroes. It's quite easy to subconsciously create lyrics or music that's similar to original works. I would always advise you to listen or watch back your track or video for similarities between your work and original works that you know. If you can spot a similar song, and you had access to that song, and the similarities are sufficiently close, numerous and extensive, I'd be careful. You're more likely to be found to have copied. But copying in and of itself doesn't necessarily amount to infringement. You'll need to have copied what's called a substantial part of the original work. Now, I've put here that it's a qualitative test and not a quantitative test when determining what is a substantial part. What I mean by that is, you can take just 4 bars of someone's musical work and it still amount to infringement. It's about the quality of what you take that counts. The bottom line is, if you hear similarities, ask yourself whether you can change the relevant element of your track or video to something more original. Lastly, I've mentioned a distinction between primary and secondary infringement. Even if you yourself haven't copied or substantially copied an original work, it's always possible that a band member has, and if you upload and distribute the track or video, when you know or have reason to believe that a band member has copied, you could be liable as a secondary infringer. The practical tip here is, if you have reason to suspect that a band member's contribution isn't original, make inquiries of that band member and don't use their work if it transpires that it has been lifted.
Guys, I hope this video has been helpful. I wish you the very best with your musical endeavours. And lastly, I just want to leave with an offer that if there's any subject that's relevant to musicians that you'd like us to cover, however mundane, we'd happily cover it. And if someone in my team doesn't have the relevant knowledge, we'll get someone on who does. Thanks very much again, and good luck with your music.